Hello everyone. So today we'll be learning about Article 32, one of the most very important articles in the Constitution, especially Article 32 and Article 226 plays a very important role. Now, if you're a law student who's preparing for your law exams, or if you're a general being a lawyer, it's very important for you to know Article 32 as well as Article 226. And most of the cases, even the PIL, that is like public interest litigation, is basically filed in this particular articles of Article 32 and Article 226. That we'll be discussing much later, but for the time being, try to understand about the important essence about Article 32 as a whole. So in case if you have not watched my previous video about what is Article 30, about the basic articles about from 12 to 14, at the end of the video you can find out even the videos for it as a whole together bunching box. You can just click over there and then you can revisit on my previous videos. Now let's get started without any further delay. Now what is this Article 32 speaking about? Article 32 says about this writs, all this kind of writs, which all we're going to learn, that comes under this particular ambute about 5 writs comes under this Article 32. Remember, now I've just taught you only one thing: habeas corpus, mandamus, certiorari, prohibition, quo warranto. All these 5 writs comes under what? It comes under Article 32. That's it. Now, what is this Article 32? For example, if an individual's rights have been violated, remember, if an individual's fundamental right or individual's rights has basically been violated, then I can go directly approach the High Court or I can directly approach the Supreme Court. If I want to directly approach the Supreme Court, then I will be using which article? I'll be using Article 32. Okay, I'll be using Article 32. Remember this because for moot court competition, they might ask you under which particular article are you present this particular court. You have to tell that Article 32, I am into the Honorable Supreme Court because my individual right have been violated. Then I will approach the Supreme Court. If the same case, I can even approach towards the High Court. Okay, under which article? Under Article 226, same thing. See, Article 32 speaks about Supreme Court if my individual right is violated. Article 226 says about I can directly approach the High Court if it is violated on my same any of my fundamental rights. Plus High Court has extra jurisdictional powers that you don't need to know now. Just learn about Article 32 purely, that is more than enough for now. Now, what are the features of Article 32? Article 32 protects the fundamental rights. First point is very clear. Article 32 protects what? It protects the fundamental rights. Point number 2. It falls in the part 3 of the Constitution. As such, it basically ensures that there is a protection of this fundamental right. Same point only that I've repeated twice, but for you to understand in a very crystallized manner. Article 32 is for protecting what? Protecting the fundamental rights. So now I've completed the first point, second point, and about the writs. I'll be explaining to you every detail about these writs also in much detail. Now, the Supreme Court has given 5 writs, basically 5 writs for the protection and the guarantee of these fundamental rights. So for protection of this fundamental rights, Supreme Court has given how many kinds of writs? All these 5 kinds of writs. Now, Ambedkar has called this article as the heart and soul of the Constitution. So tomorrow for your judiciary exam, for any of these exam, they ask you which article is the heart and the soul of the Constitution. Close your eyes and write very clearly, that is Article 32. Okay, very clear. So concluding very quickly, Article 32 speaks about what? Article 32 speaks about if my individual rights have been violated, my fundamental rights have been violated, I can go directly approach the Supreme Court or the High Court. Under the Supreme Court, now dealing only with Article 32, I can approach the Supreme Court. So these are the 5 kinds of writs we just read now. We are going to deal with one by one. But there's an important case you need to know. Under the Union of India versus the Paul Manikam case, it was said that, see, under Article 32, I can approach the Supreme Court. But before approaching the Supreme Court can sometime ask you, why are you aware? Why didn't you approach the High Court? They will ask that question. That same thing was even brought up in this particular case. Now, should direct the reason on why it has not approached the High Court before coming to the Supreme Court. So now, for example, because of Article 32, you're going directly to the Supreme Court, they will ask you the reason why you have not gone to the High Court before coming to us. So the same sentence was basically used even in the Union of India versus the Paul Manikam case. So you can even write on this particular case law. Little bit important also. Okay, now let me just so now let's go into the each writs one by one. First writ is called as habeas corpus. I'll repeat once again. The first writ is called as what? The first writ is called as habeas corpus. Now, what do you mean by the habeas corpus? That means that if a person has been illegally detained by the state, detained means what? For example, your name is Kamal. Okay, I am basically arresting you without any particular reason. Then Kamal's friend or Kamal himself, he can directly go approach the Supreme Court or the higher court, and he can tell that, Your Honor, see, this police officer Pawan has basically arrested me without any particular reason or no particular grounds. Then through the habeas corpus, you will basically be released. Simple as that. Okay. Habeas corpus means it is basically also known as to have a body. Okay. To have a body illegal detained by the state. Then he himself or the relative or his friends can basically approach the court, and habeas corpus can be used for his release. High Court or Supreme Court ask the reason for detention. So the High Court and Supreme Court who's sitting in that bench, they can ask me, Pavan, why did you arrest Kamal? Now, if I don't provide any reasonable means, you will basically be released out of it. Now, remember, for the following reasons, or for the following four reasons, habeas corpus cannot be filed. Which are the four reasons habeas corpus cannot be filed? Point number one, that is called detention is lawful. Now, if you have been arrested with a lawful means, then you cannot go directly. Simply each time you're arrested, can you go approach the court and tell that no, I've been arrested? No. Only when you've been arrested without any particular reason, I'm not telling you the himself the reason, without any reasonable factor, only then you can approach the court. Contempt of the court. If there is any contempt of the court, better they will be basically be, you cannot approach the court. Detention is outside the jurisdiction of the court. Remember, detention, arrested, which is outside the jurisdiction of the courts. For example, any particular ambit, even it could be about military aspect. If they are arresting you, then yes, for an extent, yes, you can also be under, you can basically be detained. You cannot approach the court. There are certain grounds for it. We'll be discussing that later. But for the habeas corpus, just focus on these things. Detention is by a competent court. By detention by a competent court. If a fixed court is basically deciding that you should be in jail, you cannot directly go to the court and ask for habeas corpus. No. In the famous case of Rudil Shah versus the state of Bihar, a person who was already completed his sentence was given extra 14 years in jail. That means that in Rudel Shah versus State of Bihar. Remember, okay, there was one person. In this case, I'm like, the person was arrested and he completed his sentence. For how much years he completed, depending on what the court has said, he completed his sentence. Now they again made him to be in the jail for next 14 years. They were planning him to make. They wanted him to be in the jail for next 14 years. So then he directly approached the Supreme Court, High Court, and he said that, Your Honor, listen, I have completed my sentence. Now you cannot, they cannot arrest me because I've completed my service. So this particular person was basically released. Very simple as this. Rudal Shah versus state of Bihar. So this is a very important components. We learned about habeas corpus, under what grounds can we remove person, on what grounds we cannot file an habeas corpus, and the famous case of Rudal Shah versus the state of Bihar. So now I'll be showing you about the next important kind of writ. We'll go to the mandamus. Now, let's learn about what is mandamus. I'll use my pen over here. Okay, mandamus means what? Mandamus basically means it's a form of a command. We command, okay, perform the public duty. Okay, constitutional. See, performing of the public duty, which basically means that, you know what? If I am an officer, if I'm not performing my duty with the power of mandamus, the court can basically direct me to perform my duty. Simple as this. Now, I am a government official. I am basically sitting in my office, I'm not doing any work, apparently not addressing the grievances, that this. I'm just giving you one of the lamest example. Then you as an individual go to the court, complain that, see, under the mandamus, I'm not performing my public duty. Then the court can direct and instruct me to perform my duty. Okay, through the show cause notice and all, it's possible. Mandamus, we command, perform public duty. It can be a constitutional, statutory, non-statutory, university, tribunal. So this, to perform the duty can be on any of these bodies also, constitutional, statutory, non-statutory, this one. But the important aspect is you just need to know that about the performing of the public duty, for whom they can command. For they can command to constitutional bodies or authorities, or statutory bodies, like for example RBI, SEBI, non-statutory universities, tribunal, NGT, or university in specific. If they're not doing it, then they can direct. Now in the famous case of Gujarat State Financial Corporation versus the Lotus Hotels. Okay, now Gujarat State Financial Corporation versus Lotus Hotel, what happened is that this Gujarat State Financial Corporation, they said that, okay, we will be giving you money, but you go ahead and construct, you proceed with the construction. What did Gujarat State Financial Corporation say? That financial corporation said that, made an agreement with the Lotus Hotel. They made an agreement stating that we will release funds and you can produce, you can proceed with your construction. I'll give you money, you can proceed with what, you can start with your construction. But later, no funds was not given. Okay, who didn't give funds? Gujarat State Financial Corporation didn't give funds. Now these people were intense because they bought raw materials. That happened, this happened, everything happened. Still not produced. They went to the court. They under the under the habeas corpus, I mean like under the mandamus, they filed a complaint and court held that they made this authority, is a financial corporation, to pay the money for these people and to perform their duty. This is mandamus. Very simple. Mandamus means we command, perform your duties, either for constitutional, statutory, university, tribunal, and the famous case of Gujarat State Financial Corporation versus the Lotus Hotel. Now let's see about the next important type of writ. Okay, now we'll be learning about certiorari. Now we are learning the third writ. First writ we learned about habeas corpus. Clear? Very simple. Habeas corpus is arrested without any particular reason. Mandamus, to perform a public duty. Third one we learned about certiorari. What do you mean by certiorari? Certiorari means, I'll just use this pen. Yeah. Certiorari means to be certified. What is called? To be certified. High Court and Supreme Court and High Court can give command to the lower courts to submit their records for review. That means that Supreme Court, and High Court, if there is any low court, you know the hierarchy of court, no? We have Supreme Court, we have then High Court, and then we have the lower courts. Okay, we have the lower courts. Now Supreme Court and High Court, they can instruct these lower courts to submit the records of their review for reviews to check whether the lower courts judgments are illegal. Okay, that means that they can say that now you what not case, now which case you're dealing with, are baba, you give it up to us, let us have a review about what you have done exactly about this particular case, or it could be a judgment. Okay, now in case if those reviews to check when such lower court judgments are illegal, then they can basically remove that particular kind of ambute. I'll explain to you once again. Now, Supreme Court and High Court can give command to the lower courts to submit their records for the review. For reviews, to check whether the lower court judgments are illegal. The judgment which has been passed by the lower courts, they will check whether those is it illegal or not. Now you have to check what is the meaning of illegal. Is there been any excessive jurisdiction? That means that is there any over jurisdiction done by the lower courts? Then they can declare, they can remove that particular they can remove about that purview of that judgment. Now second one is about lack of jurisdiction. If the lower courts have not performed that jurisdiction very effectively, then still they can put that rad over there. Jurisdiction is unconstitutional. Principles are violation of natural justice principle. If judgments are found illegal, then they can be quashed. They can basically be quashed. Remember, High Court and Supreme Court can instruct the lower courts to submit the records of review. And if they found that in that review there is illegal ambute in their judgment, example like where there is excess of jurisdiction, lack of jurisdiction, jurisdiction is unconstitutional, what the lower court they wrote is completely unconstitutional, if they're going against the principle of natural justice, if judgments are found illegal, then they can be quashed. They can be quashed. Okay, so in the famous case of I. Gullapalli Nagashwara Rao versus the APSTRC and the AK Kripak versus Union of India, the writ of certiorari was applied. Okay, in this both the case, remember, the writ of certiorari was mainly applied. And the lower court judgment was considered illegal and was quashed. Quashed means they can basically scrap it out. They can tell them, no, this judgment cannot be proceeded further. Simple as this. So now certiorari, High Court, Supreme Court, you can basically instruct the lower court to submit the review for the records. Now if those records, remember, if those records are basically being illegal, if there is excess jurisdiction, lack of jurisdiction, jurisdiction is unconstitutional, what not, they are going against the principle of jurisdiction or principles of natural justice, there is not equality, I'm like not giving every person considering equal under the eye of law, and if the judgment is being really vague, it can be quashed. By whom? By the High Court or the Supreme Court. These are the two landmark cases. One is Gullapalli Nageshwara Rao case and AK Kripak Union of India. So now let's look into the next important ambute of prohibition. Okay, so now prohibition, we have all learned about this aspect called as prevention is better than cure. You have learned that, no? Prevention is better than cure. Now in certiorari, certiorari, we learned about stopping. For example, if an judgment is considered to be illegal, then it can be quashed. This is after the judgment is made. Okay, just imagine I am the lower court judge, I'm making this judgment. Okay, and this judgment is considered illegal, it can be quashed by High Court and Supreme Court. Now in case if before I proceed with that case, directly the Supreme Court and High Court can tell it, Pawan, don't go ahead with this case because it is beyond your jurisdiction to perform. If they themselves have been forbidding me to do it, then there is no need for me to do it. So it's like prevention is better than cure. I'll explain to you once again. If any judgment is announced and it is considered illegal, remember, then to quash, writ of certiorari is used. This we already learned it in the previous certiorari itself. We learned it. Okay. if any judgment is announced and it is considered illegal, remember, break the sentence once again. If any judgment is announced, I am announcing my judgment. If it is illegal, then it's a certiorari. Now there's other case for it. Now prohibition means to forbid. It's issued before the lower courts announce a judgment. So before I give my judgment itself, the High Court and Supreme Court can basically stop me and telling me that, Pawan, this is beyond your jurisdiction. You're not supposed to write judgment for it. You're not supposed to proceed with this case. Then I can stop the case immediately. Who has this power? It is coming under the one of the writs. Okay, so the individual can go tell it, Your Honor, see, the lower court is doing this particular ambit and they're not supposed to do it. You please do direct them. So the High Court or Supreme Court can direct me in terms of prohibition. Okay, in the famous case of Hari Vishnu Kamath versus Ahmad Ishaku case, what happened was that when an inferior court takes up a matter which has no jurisdiction, remember, when an inferior court takes up a matter which has no jurisdiction, that means that it is not beyond my powers to perform that act, to forbid it from the continuing the proceeding. If the court hears the matter and gives decision, the writ of certiorari used to quash the decision. This is the case which we could use it for certiorari, but I'm just telling you in general. Okay, here the judgment was passed. That's the reason it was considered illegal, and it is certiorari. Now, before I pass the judgment, in case if I get stopped, that is basically coming under the ambit of prohibition. Okay. Now, the last one is quo warranto. What do you mean by quo warranto? By what authority? Okay. Court can ask any person on what grounds is he holding the public office. For example, I am a civil servant. Just imagine, I'm a civil servant. Now they can ask me, if I am not a civil servant who has not cleared my UPSC exam, then on what grounds can I go sit over there? Right. If I'm not able to prove my title that I was the person who's been qualified to sit over here, if I don't prove that, then I have to remove from my post. I should be removed from my post. I'll give you an example. Okay, many of these colleges conduct this entrance exam. Right? Many of these colleges conduct this entrance exam. Now, during this process, what happens is like, during this process, if I don't clear the entrance exam, and by that only I'll just come and enter into the college. Just imagine, without management quota, doing some fraudulent mean, university can remove me at any point of time because I didn't follow the normal protocol. Similar way, if you have been appointed to any government position or a public office without any qualification basis or without any particular grounds, then you are supposed to, if it has the defective title, will be removed. That means you will be removed from that post immediately. So in the Lankanpal versus the A.N. Roy case, this A.N. Roy was appointed as a Chief Justice of India, overlooking seniority of the Justice Hegde and Growth. Okay, I'll just explain to you this case. Then if you want, you can go to the definition. Okay, so Langpal versus A.N. Roy. So this was during that Indira Gandhi time. Okay, remember one of my teachers also very beautifully telling this case. Okay, so this was during the Indira Gandhi time in which they wanted A.N. Roy to become the Chief Justice of India. So what did they want to become? They want him to become the Chief Justice of India. But the problem was that, now listen carefully, but the problem was that in order to become a Chief Justice, there's some seniority level it has been considered. So this is A.N. Roy. Okay, this is A.N. Roy. But according to the list, there should be three people. Only after these three people finish, only A.N. Roy can become Chief Justice. But Indira Gandhi, through like during that time ruling government, they made A.N. Roy as a Chief Justice. They didn't give these three people to basically proceed with the Chief Justice post. So these people, they filed a case against quo warranto in the Supreme Court. Okay, quo warranto in the Supreme Court. But this case was not held. Why? What happened? While proceeding with the case, these three people resigned. So obviously, the three are removed. The next fourth position was apart to A.N. Roy itself, right? So the quo warranto was not applicable. But yes, still a very famous case. So I hope you understood about what is habeas corpus. We learned about mandamus, we learned about quo warranto, we learned about certiorari, and then we learned about important cases. So that's all for today's video. Hope you liked it and hope you understood something rather than nothing. So if you like this video, please like, share, and subscribe, and do let me know what kind of more contents you want me to upload videos on, so that I'll be surely doing it. So catch you all for the next video. Until then, goodbye, take care.